4 pieces of paper decide something most people never think about until the day they actually need it. If you lose the ability to make decisions for yourself, even for a short time, these 4 documents decide who can pay your bills, who can talk to your doctor, and who speaks for you in a hospital room. Without them, the answer is not your spouse or your adult children. In nearly every state, the answer is a judge, appointed to a court process called guardianship, a process that commonly costs families several $1,000s and can take many months before anyone touches a single account. With the 4 documents in place, that same authority can cost a few $100s or less, often signed in a single afternoon. Today I am giving you all 4 documents by name, what each one actually does, the mistake inside each one that catches people who think they are already covered, and the exact order to put them in place. My name is Robert Hensley, and every week I go through the actual federal rules and the actual state laws that decide what happens to your money, because the agencies rarely explain any of this in plain language. I am not here to sell you anything, and if you are new here, hit subscribe and tap the bell now, because new videos post every Wednesday and Sunday. Marriage does not grant this authority, and that surprises almost everyone the first time they hear it. 50 years of marriage grants 0 legal authority over an account that carries only one name. Your children cannot sign for you. Your closest friend cannot either. In the entire United States, exactly one kind of person can be given legal control of your finances once you lose capacity and no documents exist, and that is a judge in a courtroom in a process your family did not choose and cannot skip. Picture a couple named Harold and Wanda. Harold is 74, lives outside Dayton, Ohio, and spent 38 years running a small hardware store before he retired. Wanda managed the house and the family the same way her own mother had. For decades, the arrangement between them was simple. Harold's name was on the retirement account, the certificates of deposit, and the larger savings account. Their checking account was joint. That arrangement worked without a single problem for over 4 decades, which is exactly why neither of them ever felt an urgent reason to change it. Last spring, Harold had a stroke while clearing leaves from the gutter. He survived, and doctors helped him regain much of his movement, but the stroke affected his speech and his ability to process complex decisions. In the language his medical chart used, Harold had lost capacity. 9 days later, Wanda walked into the bank they had used since the 1980s to move money from Harold's retirement account and cover a medical bill their insurance would not pay. The banker knew them both by name and clearly hated saying what came next. "I am sorry, Wanda. You do not have authority on this account." Wanda said what most spouses would say in that moment. "I am his wife." The banker, who was legally correct, explained that without a power of attorney, only Harold could authorize that transfer, and Harold was no longer able to. That is the entire trap, stated in 2 sentences. The one person who could have given Wanda authority was the one person who could no longer authorize anything at all. The document that would have prevented this takes about an hour to complete, while both people are healthy. Wanda had exactly one path left, and it ran through the courthouse. For 7 months, while a guardianship petition moved through the system, Wanda ran their household out of the one joint checking account her signature can still reach. She postponed a roof repair. She borrowed quietly from her son. A woman with plenty of money spent most of a year living like a woman with very little, because nearly all of it sat on the wrong side of a signature line. Here is what that guardianship process actually involves, because the term sounds far gentler than the reality. Your family must first petition a court to have you formally declared legally incapacitated. That is the required first step, arguing in front of a judge that someone they love can no longer manage their own life. There are filing fees. There is an attorney for the family. In many states, a separate attorney is appointed to represent you, paid for out of your own funds. There are medical evaluations and court investigators, and in many states a bond, similar to an insurance policy, that your estate also pays for. By the time a routine, uncontested guardianship case is finished, families commonly spend several $1,000s. A contested case where relatives disagree about care or about who should be appointed can run into the tens of thousands, paid out of the very savings the case is about. Guardianship is also not a one-time event. It is ongoing supervision. The appointed guardian must file inventories, annual accountings, and receipts, and must ask the court for permission before major decisions, selling a house, moving investments, or making a large gift to a grandchild the way you may have done freely your whole life. Depending on the state, a full guardianship can also remove other rights, including where a person lives, and in some states, the right to marry or vote. This is not because anyone involved is cruel. It is because once a court declares a person incapacitated, the law is thorough about it. And when family members disagree, or live far away, or a judge has concerns, courts sometimes appoint a professional guardian instead, a licensed stranger who manages the finances of many people at once and is paid hourly from each person's own savings. Picture a woman named Colette. Colette is 80, lives in Tucson, Arizona, and taught piano out of her home for over 30 years. 2 years ago, her memory began slipping in small ways. A bill got paid twice. Her utilities were briefly shut off. A landscaping crew she did not remember hiring cashed a check for several $1,000s. Her 2 sons flew in from different states, found no power of attorney and no healthcare documents anywhere in the house, and learned that Colette could no longer legally sign one herself. Because the sons disagreed about her care, one wanted her closer to him, the other wanted home care where she already lived. The guardianship case became contested. It dragged on for over a year, with separate attorneys, evaluations, and repeated court dates. Because the brothers could not agree, the judge appointed neither of them. Instead, a professional guardian took over Colette's finances, a woman Colette had never met, who now approved her grocery spending and her medical decisions. Legal fees and guardian fees consumed tens of thousands of dollars of Colette's savings within the first 2 years alone. Both sons loved their mother the entire time. Every dollar of those fees and every month of that delay was the price of documents that were never signed. So let us put the documents in place, starting with the single most important one in this entire video, the durable power of attorney. A power of attorney is a document where you, while healthy and of clear mind, name a person you trust to manage your finances if you ever cannot. This person is called your agent, and they can pay your bills, manage your accounts, and deal with insurance companies without a courtroom ever hearing your name. Now, the most important word in that sentence, durable. A basic power of attorney, the kind sometimes used for a single transaction like a real estate closing, can automatically end the moment you lose capacity, which is exactly the moment it would actually be needed. The word durable, included in the document itself, is generally what keeps the authority active through incapacity, though the exact requirement varies from state to state. So check the specific language your own state requires. One clarification matters before we go further. because it changes how urgent this actually is for many households. Capacity is not one single switch that flips on a specific date. Courts and doctors generally treat capacity as decision-specific, meaning a person can lose the ability to handle complex financial paperwork while still clearly understanding simpler choices, or the reverse. In the earlier stages of memory conditions like Alzheimer's, many people remain fully capable of understanding what a power of attorney means and who they are naming, even while other parts of daily life have grown harder. This means a diagnosis already sitting in your household is not automatically a closed door. If there is a diagnosis on the table right now, the answer is not despair. The answer is speed. An elder law attorney handles exactly this situation on a regular basis and can meet with a person soon after diagnosis specifically to document capacity at the time of signing. Waiting for symptoms to progress further only narrows the window, and nobody, not even a doctor, can tell you in advance exactly when that window closes. There is a second trap worth knowing before you sign anything: the springing power of attorney. Some documents are written to only take effect once one or more doctors formally certify incapacity. It sounds cautious on paper, but in practice, it can mean your family chasing physician letters for weeks while bills go unpaid, and arguing with banks about whether the document has technically taken effect yet. Many attorneys who handle this work regularly prefer a document that is effective immediately when signed, held by an agent you trust completely, because the entire value of this paper is speed. Third, choosing your agent. This is a decision about trust, not about fairness. Do not name two adult children jointly simply to avoid hurt feelings, especially if those two children rarely agree on anything. Name the one who is naturally organized with money and paperwork. A power of attorney built to keep the peace between siblings instead of to actually function can end up rebuilding the same courtroom situation, just with extra steps added on top. One more practical detail that trips people up: the signing requirements themselves. A power of attorney is not valid just because you wrote your intentions on a piece of paper. Most states require the document to be signed in front of a notary public, and a meaningful number of states also require one or two additional witnesses who are not the named agent and not related to you. Skipping this step is one of the most common reasons an otherwise well-written power of attorney gets rejected later by a bank or a hospital. Notaries are available for little or no cost at most banks, many shipping stores, and some public libraries. If you are signing an attorney-drafted document, the attorney's office typically has this already covered as part of the appointment. If you are using a free statutory form on your own, confirm your state's specific witness and notary rules before you sign, because a document signed incorrectly can leave your family in exactly the same courthouse situation this entire video is trying to help you avoid. Now, let me answer the objection that stops more people from signing this document than any other. I am not ready to hand over control of my money. Good, because that is not what this document does. You keep every account. You keep every single decision. You can override your agent at any time, and you can cancel the entire document with your own signature for as long as you remain capable. It is not a transfer of power. It is closer to a spare key, cut now while you are able to sign for it, kept in a drawer for a door you hope never sticks. If trust is even a small concern, you can build safeguards directly into the document. You can require your agent to share account records with the rest of the family, or require a second person to co-sign any transfer above an amount you choose yourself. An attorney can add language like this in a matter of minutes. A power of attorney with those safeguards is still far faster than a courtroom, and it costs a small fraction of what a guardianship case does. Now the cost. Many states publish a free statutory power of attorney form, and legal aid offices help seniors complete them at no charge. An attorney-drafted version, written specifically for your state, typically costs a few $100s, though fees vary by state and by attorney. Hold that number against the tens of thousands Colette's family lost. One instruction I want to make impossible to miss: both spouses need their own document. Harold needed authority over accounts in his name, but if the stroke had affected Wanda instead, Harold would have been the one standing at a different counter, blocked from whatever carried her name. Incapacity does not check whose name appears on more paperwork. Two spouses, two documents, often signed the same afternoon in front of the same notary. But even a perfectly valid notarized power of attorney can run into a second problem entirely. Picture a woman named Beatrice, 78 years old, living outside Billings, Montana. Her husband did everything correctly years earlier. A durable power of attorney drafted by a lawyer, naming Beatrice as his agent. When her husband's dementia progressed, Beatrice brought that same valid document to his brokerage firm to move funds for his care. The firm did not refuse it outright. They said the document needed to go through internal review before anyone could act on it. That review took 19 days. 19 days during which a document that had been legally valid the entire time simply sat in a compliance queue, while Beatrice covered expenses from her own smaller account. This happens because valid is not the same as accepted, and accepted is not the same as accepted quickly. Banks and brokerages often hesitate over what they call staleness, a document signed many years earlier that they cannot easily confirm is still current or has not been replaced by a newer one. Reviews like this often trigger automatically whenever a request involves moving significant money or changing account ownership. Exactly what incapacity tends to force all at once. Which brings us to document number 2. And it is barely a separate document at all. It is closer to a habit. Every major bank and brokerage has its own internal power of attorney form, already approved in advance by their own legal department. Walk into your bank or brokerage together while both of you are healthy and say one simple sentence: "We would like to put your institution's own power of attorney form on file for our accounts." An outside document gets reviewed. Their own form gets processed. Same legal protection, without the 19-day wait Beatrice experienced. While you are there, add 2 more small habits to the same visit. First, if your existing power of attorney is more than 4 or 5 years old, consider signing a refreshed version with a current date. A recent date is often the simplest fix for the staleness objection banks raise. Second, add a trusted contact to every account you hold. This is one name and one phone number, someone who gets no access and no control over the account, but who the bank or brokerage can call if something looks unusual. This costs nothing, takes only a couple of minutes, and for brokerage accounts, it is now required under a nationwide industry rule adopted in 2018, specifically designed to give the firm a lawful way to check on an account before acting on a request that looks unusual. While you are building these protections, it helps to understand why banks have grown more careful about all of this. Financial exploitation of older adults has become a well-documented and growing problem, tracked by federal regulators, including the Consumer Financial Protection Bureau. Often carried out by strangers running scams, but sometimes by trusted family members or caregivers instead. This is part of why the trusted contact system exists, and why some banks now offer optional alerts or temporary holds on unusual withdrawals from older customers' accounts. None of this replaces your power of attorney or limits your own control over your own money. It simply gives your bank one more way to pause and ask a question if something looks wrong, the same way a fraud alert on a credit card works. Ask your bank directly whether they offer enhanced monitoring for older account holders, since this varies by institution and is worth adding to the same visit where you file your power of attorney. Reports to state adult protective services agencies involving financial exploitation have climbed substantially over the past decade, part of why bank staff increasingly receive training to spot warning signs before money leaves an account. Document 3 covers a completely different front, the hospital rather than the bank. Two papers guard this side, and they do different jobs. The first is the healthcare proxy, sometimes called a medical power of attorney or a healthcare surrogate designation, depending on your state. This document names the person who makes medical decisions on your behalf when you cannot, which treatment to pursue, which facility to use, which doctor to trust. Without it, many states fall back on a default list written into state law. And that list has no idea which of your children actually shares your values, or which one is not called in years. The law simply reads down the list in order. Naming your own proxy replaces that guess with your actual choice. It is worth checking your specific state's rule here, because not every state has a default surrogate law, and in states without one, the absence of a named proxy can leave medical decisions genuinely unclear at the worst possible moment. Where a default list exists, it typically runs spouse first, then adult children, then parents, then siblings, though the exact order and whether children must agree unanimously varies by state. The second paper is the one almost everyone forgets, the HIPAA release. HIPAA is the federal medical privacy law, and it is the reason a hospital cannot simply discuss your condition with anyone who calls in asking. Hospital staff are generally allowed to use their own professional judgment to share basic updates with family members who are clearly involved in your care, even without paperwork on file. But relying on a staff member's judgment during a stressful night is not the same as guaranteeing the answer. A signed HIPAA release removes that uncertainty completely. It is typically one page. It simply lists the people your medical team is authorized to speak with, and it grants no decision-making power at all, only information. Picture your daughter calling the hospital from 2 states away on the hardest night of her year, and being told the staff cannot confirm any details because no release is on file. The staff member is following federal law as written, and one signed page in advance would have changed that entire phone call. Document 4 is the instructions themselves, usually called a living will or an advance directive. The proxy from Document 3 decides who speaks for you. The living will tells that person what to actually say. It is your own wishes, written down in advance, about machines, about feeding tubes, about comfort-focused care. The decisions no family should have to guess at beside a hospital bed in the middle of the night. I will not tell you what to write in it. That part belongs to you, your beliefs, and your family. What I will tell you is what its absence does. Without it, the hardest question a family will ever face gets handed to the people who love you most, with no instructions, at the worst possible hour, with every relative remembering something different that you once said years earlier. Families have genuinely split apart over that one missing page. Most states offer free advance directive forms, and hospitals hand them out at no charge. So the only real cost is one honest evening of conversation. In some states, the living will and the healthcare proxy are combined into one document. So check whether your state offers a combined form before filling out two separate ones. Do not simply sign the living will and file it away quietly. Tell your proxy directly what the page says and why you chose it that way. Because a proxy who heard you explain your wishes out loud stands far steadier in that hallway than one reading your words for the first time under hospital lighting. Here is a short exercise worth doing tonight with your spouse or partner. Take a sheet of paper and list every account and asset in your household: the retirement account, the savings, the certificates of deposit, the house deed, the vehicle titles. Beside each one, write down whose signature currently controls it. Now cover each name in turn and ask one honest question. If this particular signature stopped counting tomorrow, could the other person actually run this household? Every line where the answer is no is a line where one of you is currently exposed the same way Harold and Wanda were, and that single page is worth completing before you move on to anything else tonight. It is also worth repeating the same exercise once a year, since new accounts and new assets get added to a household far more often than the documents protecting them do. There is one more legal layer worth knowing about: digital assets. Many states have adopted a law called the Revised Uniform Fiduciary Access to Digital Assets Act, which specifically addresses whether your power of attorney agent can legally access your online accounts, email, and digital files, separate from simply knowing your passwords. Under this law, your power of attorney document can explicitly grant your agent authority over digital assets, and many attorney-drafted documents now include this language automatically. A document that predates this law, or a free generic form that never mentions digital assets, may leave your agent in a legal gray area with certain online providers, even with your password in hand. When you sign or refresh your power of attorney, ask specifically whether digital asset authority is included, combined with a written list of your logins kept alongside your documents. This closes one of the newest gaps in this entire system, a gap that simply did not exist for your parents' generation. Many online providers also let you name a legacy contact directly in the account settings, which is worth doing in addition to, not instead of, the language in your legal document. Once everything is signed, where you keep it matters almost as much as the signing itself. Keep the original durable power of attorney somewhere your named agent can actually reach, without needing you to unlock a safe deposit box that also requires your own signature to open, which happens more often than people expect. Give signed copies directly to your agent, your backup agent, your primary doctor's office, and any bank or brokerage where you filed their internal form. Some states also offer a power of attorney registry where the document can be recorded for easier verification later, similar to how a deed gets recorded. Naming a backup agent in addition to your primary choice matters here too, because if your first choice becomes unavailable or unable to serve, whether from their own health issue, a move, or simply being unreachable, a named backup keeps the whole system working without a gap. A document sitting alone in a drawer nobody else knows about protects nobody, no matter how carefully it was written. Tell at least two people where the originals live, not just one, so a single missed phone call never becomes the reason the whole plan stalls. One warning before the final checklist: because of fear, this reel also attracts people looking to profit from it. There is a circuit of free dinner seminars where these same 4 documents are used as an opening pitch, leading into expensive bundled document packages and insurance products with long surrender periods attached. Hear this clearly. Nothing in this video requires a paid package of any kind. Many states publish free statutory power of attorney forms. Hospitals hand out advance directives at no cost. Your bank's internal form is free. Legal aid programs and your local area agency on aging can help seniors complete all 4 documents at little or no charge. A real attorney is genuinely worth a few $100s for a properly drafted, durable power of attorney tailored to your state. A stranger who needs your signature the same night you ate a free steak dinner is not selling protection. They are selling urgency. And now you know exactly how to tell the difference between the two. If anyone pressures you to sign before you have had a chance to read the document at home, that pressure alone is reason enough to walk away. Here is the entire plan, spread across 1 week. On the first day, decide your people, your financial agent and a backup, your healthcare proxy and a backup, chosen for function rather than for fairness between siblings. On the second day, sign the durable power of attorney, attorney drafted if you are able, your state's free statutory form if you are not. Confirm the word durable actually appears in the document, and complete the notary and witness requirements your state sets. On the third day, visit the bank. Put their own internal form on file at every institution you use, and add a trusted contact while you are already standing there. On the fourth day, complete the medical pair, the healthcare proxy, the HIPAA release, and the living will, using the free forms your hospital or your state provides. On the fifth day, tell the people involved, hand copies to your agents and your doctor, place the originals somewhere your family already knows to look, and mark a date 1 year from now to review all 4 documents together. Let us recap quickly. Document 1 is the durable power of attorney, giving someone you trust legal authority over your finances if you cannot act, with the word durable written directly into it. Document 2 is your bank's own internal power of attorney form, plus a trusted contact added to every account, so nothing sits in a review queue for weeks. Document 3 is the healthcare proxy paired with a HIPAA release, so the right person can make medical decisions for you and your family can actually get information from the hospital. Document 4 is the living will, your own instructions written down in advance, so nobody has to guess. Everything in this video is general education based on federal law and common state rules, not personal legal or financial advice for your specific situation. So confirm the details with an elder law attorney or your own state's rules before you sign anything. If you know a parent, a spouse, or a friend this could help, share this video with them today. And if you have got a question about your own situation, drop it in the comments. Every Friday, I answer real viewer questions over on my posts tab. If this helped you, hit that subscribe button and the bell so you catch every video the moment it goes live. You still depend on every one of these decisions, and now you know exactly what to do with it. This channel provides educational information only and is not affiliated with the Social Security Administration, Medicare, CMS, the IRS, or any bank.